Hey guys, it's Kathy. I hope you're doing well. All right, we're live. We're live everywhere. So, I think I got it to the part where we stopped, but really I'm not 100% sure. And I'm not 100% sure I was paying attention when we played part one. So, I don't really know where we stopped. So, I'm going to press play, and I won't know if we've already played this before because I wasn't paying attention. But I'm going to try hard to pay attention to my own stream from now on, because that's my only job. Share my screen. We got audio. We're not muted. All right. I think we get to hear Victoria today.
Off the record. Okay, everybody, thank you for patiently waiting. I know you guys want to go. Let's go. Come on. Hi, Cena. What you got, buddy?
We're going to skip all these because really it's a 6-hour docket. We don't have time for all that. We're going to try to get back to the trial. That's the trial. Whoa, hold on. Jazz hands. Jazz hands.
Yeah, I'm doing it right now. Right.
Bilal Al-Zubayn, come on up.
Hey, Roxanne, I always waive all fees. Unless I tell you otherwise, assume that the fee's waived. So like an Emma Lynch's Jarbon, I'm gonna check the waive fee so that she doesn't have to worry about it, okay?
I thought we were getting back in the trial, but I was wrong. But that looks like the trial, doesn't it?
Yes, your attorney will prepare you to do stand contact. They're not gonna show it.
Guys, you ready?
I said I'll just have a motion real quick, but other than that. That's okay. Yeah. So.
You gonna do it now?
Well, I'm not fine.
Oh, please.
Yes, I got them reading. I got.
You're here. You're here. Guys, we are going on the record. Please do not talk. If you need to talk, please go outside.
You're not the boss of me.
Okay, so we're back on the record in the trial case, and before I ask the state to call its next witness,
No, you shush.
Ray, did you have something that you wanted to do?
I do, Your Honor. I just wanted to ask the court of following oral motion to suppress any evidence obtained from the traffic stop. I don't believe there was probable cause for the traffic stop. Officer Metter indicated that he could not tell how fast he was going, that it was less than a quarter of a mile before to the next light when my client was stopped. It took over a minute for them to get there. Therefore, whatever speed Officer Metter perceived is inaccurate. He even indicated so himself. Also, Judge, at the same time, Officer Metter said that if not for his perceived speeding, he would never run my client's license plate. And I don't believe with him not running the license plate, he even indicated that had he not perceived him to be speeding, he would have never ran his plate and therefore would have never found out about the expired registration. And on top of that, the officer also testified that the expired registration in and of itself is not indicative of driving while intoxicated. I don't believe there was probable cause to pull him over based on the inability of the officer to say how fast he was going. And I don't believe that without that reasoning, he would never run his plate. If he would never run his plate and found out the expired registration, he would never got into the field sobriety test and we would not be here. So I'd ask for all evidence to be suppressed based on the fact that the officer did not have probable cause to even run his plate or stop him to begin with.
Okay, response?
Your Honor, the state would offer that there are several arguments to be made here. The first of which is that the officer's suspicion was initially triggered based off of what he believed to be speed. He then follows that up with pacing, a method that is commonly used and applied by law enforcement. And he also verified that his speedometer was calibrated that day. Because of that, he was able to pace the defendant at a speed that, even if it was not the speed of 64 miles an hour that the officer testified to, he knew that it was at least above the posted speed limit, which on its face is enough for the officer to initiate a traffic stop. However, the officer did not stop there, he went further. And even if that part of pacing is not accepted by Your Honor, the next part that the state would argue would be that the officer's initial suspicion was triggered. He continued to have suspicion of the vehicle. And then once he got up to the vehicle, he ran the registration. As he testified, he can do on any vehicle, as is commonly accepted. That once he found that the registration was expired, he then initiated a traffic stop at the next possible moment to do so. Which, because of that expired registration, on its face is sufficient for the officer to initiate a traffic stop.
Okay, I get it. I'm going to deny your motion. I mean, I think that there's enough to go on. You know, officers, the training experience, it's a 30-mile-an-hour road. They know when it's faster than that, and then they can run the license plate for, I'm going to deny the motion. Sorry,
Your Honor.
Okay. State, you ready to call your next witness?
Yes, Your Honor.
Okay. Guys, we have a jury coming in. Hold on a second. Hold on. Mr. Bias, come up. We'll have you sign so we can get you out of here. Is there anyone else that we need to get out? Okay. Lawyers, anything else that anyone wants to talk about real quick? No? Bueller? Okay. Let's go.
At lunch, Your Honor, we're gonna make sure all our redactions were good, and we're gonna go over that at lunch break.
Yeah, we'll do that at lunch. And at least get through one more witness before lunch.
Yes, Your Honor. Can you get the jury first?
You ready?
All right.
Let's go. Come on, get
We
them.
saw this. I'm sure that we saw this because we made it to lunch. So no, Kurt, they're definitely that far away so that we can't freaking hear them. That's exactly why, just to make our lives miserable. We did this. We saw this. We're going to lunch, guys. Okay, we're at lunch. Oh, we're back. Start here.
So you're starting right now, right?
Oh, yeah.
You haven't done anything so far, am I right?
No.
Josh,
It's just a USB
Okay.
oh, I remember.
Since you have much.
I mean,
Me neither. I should get some.
leave your cell phone for it and it shows.
All right, for the jury.
Okay, please be seated. Ray, you may continue.
May I approach, Your Honor?
Please.
And I'm sorry, do you have an official title or designation or is Mr. Klein? Okay, Mr. Varner. During the break, I showed you some videos, correct?
Yes.
And those videos were contained on this USB drive, correct?
Yes.
Okay, and as far as you know, the videos that you observed are a fair and accurate depiction of what happened at that time, is that correct?
Yes.
And to your knowledge, have they been altered or modified in any way?
No.
Generating the opposing counsel for objections?
So this would be defense one.
Defense one, yes, Your Honor.
No objection, Mr. State, Your Honor.
Okay, it'll be admitted, and that is a USB of the intox room?
Yeah, that's correct, Your Honor. Two separate views from the intox room. May I publish, Your Honor?
Please.
All right, Mr. Warner, so this is the intoxilizer room at JPC, is that correct?
Yes.
And this is where suspects are taken in for their breath test, correct?
Yes.
Okay, so who do we see here in this video?
We, Officer Metter, and Reno. Got a mess. Got a mess.
Close enough. Okay, so my client, you and Officer Metter, correct?
Yes.
Okay, and we're about the 1 minute 14 second mark, correct? Can I hear
Yes,
applause? Okay. Well, I'm just going to fast forward a little bit because there's a lot of sitting around. Is that right?
Yes.
Okay. Okay, is this when you begin the breath test?
Yes.
Okay, and we're at the 6 minute and 45 second mark. Is that correct?
Yes.
Is that 15 minutes?
1:45 to 6:45. No.
And so this is where you begin the breath test, correct?
Yes.
Now you indicated on direct examination that you also check their mouths before they blow. Is that correct?
Yes.
We don't see you check his mouth there, do we?
No.
Okay, and then this is just him blowing into the device, correct?
The first sample. Yes.
Okay. And then there's a waiting period and then the second sample, correct?
Yes.
And as part of State's Exhibit State Exhibit 4. May I approach you?
Please.
Is this your writing on the second page here?
Yes.
Okay. And without going into too much detail, what does it say next to breath?
MOAB.
And what does MOAB stand for?
Moderate odor alcohol beverage.
Moderate odor of alcoholic beverage?
Yes.
And is that something that you observed or is that what you were told by the officer?
That's what I served.
So not a strong odor of alcohol, correct?
No.
And in your experience, how many times have you administered a breath test?
Almost 3,000 a year.
3,000 a year? Okay, so in all of those times, if they had a strong
Dude, he works in Harris County. It's like he doesn't do that a day.
odor of alcoholic beverage, you would indicate that, correct?
Yes,
That moderate odor of alcoholic beverage, you would indicate that, correct?
yes.
That mild odor of alcoholic beverage, you would indicate that as well, correct?
That would be moderate, it would be mild, or distinct.
Okay, so a difference between strong and moderate slash mild, correct?
Yes,
And would you agree with me that just even a couple of beers could provide moderate odor of alcohol, correct?
yes.
I'll pass it.
Okay. Anything further?
Briefly, Judge. Was what we saw in the video the entire observation period?
No,
Why not?
so the JPC, we have limited space, and we have, to talk to lot of first people. And we don't have enough time to wait on room, so we have to reserve outside for both to go to the room. Or somebody else to use the room.
Did you do that on this test?
Yes,
And was the full 15-minute period observed?
yes,
And did you check his mouth before?
yes.
So what they're asking is when you give someone a test, their mouth has to be completely empty for at least 15 minutes. They can't have chewing gum, they can't have anything like that. 15 minutes empty mouth, then you can administer the test. So that I didn't know that till recently, till we had that other DUI case. Hi, Yen.
Was everything you did on this specific test done in accordance with your standard procedure?
Yes,
Nothing further than to say, okay?
Okay. Great.
Very briefly, Your Honor.
Okay.
And Mr. Varner, just so we're clear, there are, this was done at the JPC, correct?
yes,
And that stands for Joint Processing Center, correct?
yes,
And there are cameras all throughout JPC, correct?
yes,
But you or whoever's in charge of your videos do not provide either the state or myself the video of the observation period outside, correct?
you're correct.
So the only thing that we can physically see is the 6-minute time period between the time you enter the room and the time you do the test, correct?
Yes,
Nothing further, Judge.
Okay. All right, may this witness be excused?
Nothing further than to say,
No recall, right?
No recall.
Okay. Mr. Varner, you're excused. Thank you for your testimony. Be safe. You have one final witness?
Yes, Your Honor.
Okay. You want to keep going, last witness, or do you want to? All right, state, call your last witness.
They call Stephen Cooper, this thing, Your Honor.
Okay.
Please, some pressure on your eye.
Oh my God, we see the jury. Oh my God. And my chat loses their. Nope. I love when we can see the jury and the chat goes crazy.
Your Honor, this witness has not been sworn in.
Okay, all right, Mr. Cooper, if you come on up, good afternoon.
Good afternoon.
Come up, please raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Any testimony you give will be the truth.
Yes.
Please speak loudly, clearly. If you hear the word objection, stop until we've addressed it, and then you may continue. Okay? All right. State.
Thank you, Judge. Can you please say your full name for the record?
Stephen Cooper.
And what do you do for work?
I am a forensic scientist as well as a technical supervisor.
And how long have you done it?
For about 7.5 years now.
Can you tell the jury a little bit about your educational background?
So I have a Bachelor of Science degree in biology from the University of Texas at Arlington, as well as a minor in biochemistry.
And do you hold any memberships in scientific or professional organizations?
Yes, I am a member of the International Association for Chemical Testing as the website chair. I'm also the past president of the Alcohol Testing Alliance.
And what are your current duties and responsibilities as a technical supervisor?
So they include being the custodian of records of all breath test records generated through the Texas Department of Public Safety for the area that I cover. I also train operators on the use of the Intoxilizer 9000. I testify in court for DWI trials, and I'm also in charge of the Intoxilizer 9000s in my area, performing any maintenance and inspection procedure.
And what is the Texas Breath Alcohol Testing Program?
So that is the program that oversees all Intoxilizer 9000s in the state of Texas, as well as operators being trained on the use of them for all breath DWI investigations being conducted.
And are you presently certified by the Texas Department of Public Safety as a technical supervisor?
Yes, I am.
What date were you certified on?
It was in December of 2017.
And what training do you have to have for that certification?
So it includes a several month-long training process, usually around 6 to 8 months. It includes attending various training courses taught by other technical supervisors in the area throughout the state of Texas. You also must attend various training courses outside of Texas, one of which being the Borkenstein class hosted through Indiana University, where you learn about the physical and mental impacts of alcohol in the body. You also must attend a course hosted by CMI, the creators of the Intoxilizer 9000, where they teach you how to perform maintenance of the Intoxilizer 9000. You then also must go through operator school, go through a mock trial process, and then have a written and oral test conducted.
Have you conducted any experiments on your own as to the workings and the reliability of the Intoxilizer 9000?
Yes, I have.
Are you familiar with the underlying scientific theory that the Intoxilizer 9000 instrument is based upon?
Yes, it's based upon infrared spectroscopy.
Can you explain that? What's infrared spectroscopy?
So essentially, in our instrumentation, you have an infrared light source and a photodetector analyzing that infrared light source. You can sort of envision this by, say, you're standing in a hallway holding a flashlight that's emitting light, and you have a friend at the other end of the hallway staring at the light coming out of your flashlight. Now, if you can sort of envision the hallway filled with something such as smoke, the more smoke that enters the hallway, the less light your friend is going to see. So similarly, in the instrumentation, the more ethanol in an individual's breath that fills the test chamber is going to absorb this infrared light, the less light the photodetector is going to see. And now the instrument is calibrated that as the light it sees increases, the concentration of ethanol in the chamber goes up. So it has a proportional calculation that it does at that point.
And is that theory considered valid by the scientific community?
Yes, it is.
Can you explain a little bit more about how the instrument specifically applies that theory?
So it's kind of applying it through what's referred to the Lambert-Beer law, stating that a constant temperature of pressure proportion is absorption is proportionate to concentration.
And was that technique properly applied in this case?
Yes, it was.
How do you know that?
It's the scientific basis behind the Fleischer 9000. The instrumentation related to this have been around for decades now, and there's much research behind this.
Do you know an intoxilizer operator by the name of Donald Garner?
Yes, I do.
Is Mr. Garner certified by the Texas Department of Public Safety as an intoxilizer operator?
Yes.
And are you familiar with the Intoxilizer 9000 that was used in this case?
Yes, I am.
How are you familiar with that instrument?
It's an instrument in my area that I'm regularly responsible for.
And has the Intoxilizer instrument model 9000 been approved and or certified by the Texas Department of Public Safety?
Yes, it has.
Was this particular instrument certified and operated as part of the breath alcohol testing?
Yes, it was.
And as part of your duties, you stated you're responsible for the maintenance and monitoring of the instruments in your area. Can you describe to the jury what this involves?
So one of the first things that it involves is conducting our monthly quality assurance inspections. We travel to each of our locations throughout the Houston, Galveston, and Brazoria County area that are hosted in various courthouses and police departments. The first thing that I do upon getting there is ensure that the instrument is functioning properly. We also have a simulator device attached to the side of the instrument. It contains a known concentration of 0.08 in it, and we replace that on a monthly basis. And then we run a practice test. I also blow into the instrument to ensure that it's reading a 0 for myself. If any maintenance is required of the instrument, I would take care of it, most likely by removing it, replacing it in my lab, or performing some maintenance on site if need be.
And what was the closest date before October 6, 2024 that you checked this particular intoxilizer?
That would have been September 23rd, 2024.
What was the condition of this particular instrument at that time?
It was functioning properly at that time after the technical supervisor initially forgot to plug in the simulator cable. She then plugged it in and had a complete test afterwards.
And what was the closest date after October 6, 2024 that you checked this particular instrument?
That would have been October 22nd, 2024.
And was the operational condition of this particular instrument, excuse me. What was the operational condition of this particular instrument at the time?
It was functioning properly at that time as well.
And did that particular instrument require any repairs between the dates that you checked?
No, it did not.
And do you have an opinion based upon your experience and training as to the operational condition of that instrument on on October 6, 2024?
Yes, that it was functioning properly at that time.
Government approach?
Yes.
Showing you what's been marked as 6 exhibit number 4. Can you tell me what this is?
This is a Texas forensic breath alcohol analytical report.
And as part of a particular test, is the operator required to have the subject continuously in his or her presence for a minimum period of time prior to conducting the test?
Yes, 15 minutes.
And what is the purpose of that 15 minutes?
It's to ensure that there's no residual amount of alcohol on an individual's breath that could falsely lead to higher elevations than what they actually are at.
Does the analytical report indicate that the proper operational methods and testing techniques were followed in administering this particular test?
Yes.
How can you tell that from observing the analytical report?
I can tell that by observing that first and foremost, everything's printed clearly on the page. All of the air blanks are reading 0. The operator's signature is on the page, as well as an indication that they conducted the 15-minute waiting period. There's a test complete indicated on the page as well as no incomplete test messages either.
What is the calibrated verification solution?
So now,
I'm sorry, what was that?
What is the calibrated verification solution?
so that would be the simulator that I alluded to earlier. It is the reference device containing our known concentration. The instrument reads this twice during every subject test.
Who prepares the calibrated verification solutions for use with intoxilizer instruments?
That would be myself and my coworkers.
How do you prepare these solutions?
We typically will travel to Austin and create them in a large batch. We have a large container containing several hundred gallons of water that we fill up. We add ethanol to create roughly 500 bottles of 500 milliliters. And it contains our known concentration of 0.08. And then we label them, seal them, and then we use them on a monthly basis.
And are those solutions periodically checked?
Yes, monthly.
And how is that done?
That is done at our monthly inspections. We use a new bottle every single time, and then we conduct a practice test with it.
How is the predicted value entered into the intoxilizer 9000?
So there is no predicted value entered into the intoxilizer. The instruments are calibrated in our lab, and then the calibration is verified using these simulators with the reference device, with the reference samples in them, sorry. And that's done just to verify the instrument is calibrated properly. And then when an individual blows into the instrument, it uses its calibration to essentially analyze the individual's breath at that point.
Does the analytical report that's marked as States Exhibit 4 reflect that the result of the calibrated verification system was within the tolerance level of the analytical report value?
Yes, it does.
And what happens if it's out of tolerance?
So if the instrument reads its calibration verification outside of the acceptable range of 0.07 to 0.09, then the instrument will flag an incomplete test with an exception message stating cal verification out of tolerance.
And what happens if it is out of tolerance? Or, I'm sorry, excuse me. No. What does alcohol concentration mean?
In regards to what?
The analytical report says alcohol concentration. What does that mean?
Are you referring to the subject results?
Yes.
So that would be the 2 breath samples that each subject administers throughout the breath test. They provide the first one, and then they provide the second one approximately 2 minutes later.
What steps should the operator of the intoxicator follow if taking a breath sample?
So the first thing that must be conducted is the 15-minute waiting period. Then at that time, the operator will then input the subject's information into the instrument through either scanning, typing, or swiping a driver's license. They then confirm that they conducted the 15-minute waiting period along with their signature, and then they can start the test at that point.
And then can you please describe for the jury the steps the instrument automatically?
Sure. So the first thing that occurs during this sequence of analysis is the operational system check. It's when the instrument performs an electronic check on itself to confirm that everything's functioning properly. There's then a 30-second air blend conducted. This is the instrument purging the testing chamber to ensure that there are no foreign contaminants or residual alcohol left behind. The instrument then goes through its first calibration verification check where it checks that known solution that we have attached to it. The instrument will then go through a second air blank to again purge the sample chamber. At that point,
I didn't color my hair. I didn't change my hair in any way, shape, or form at all. Everybody keeps asking, but all I did was remove the huge headset that I used to wear. And these are from the airplane. I have bought expensive ones, many pair, in the last year to get rid of that stupid headset. And none of them worked with my stream. 0 of them. I went to Texas when did I go to Texas? It was just a couple weeks ago. The airplane gave me these cheap things. I got 2 pair because I flew there and back. And I was able to remove that stupid headset now that was just really uncomfortable. But my hair is exactly the way it always has been.
the subject that provides their first breath test sample. There is then a third air blank followed by a 1-minute waiting period. And then at that point, it's just a mirror image from what I just went through, ending on the second final operational system checks.
And what were the results of the 2 breath samples of the subject in this case?
I'm going to object, Your Honor, that has not been entered into evidence yet.
What was your question?
What were the results of the 2 breath samples of the subject in this case?
Okay, Garrett?
And just again, you verified that this is the analytical report that was used for this test, right?
Yes,
I
yes.
think the judge is enjoying himself today. I don't know.
And it's a true and accurate depiction of that analytical report.
Yes.
I'm tendering State's Exhibit 4 for defense inspection.
Improper predicate, Judge.
I'm showing you again what's been marked as State's Exhibit 4. Did you review this analytical report?
Yes.
Does the information here match everything in this case?
Yes.
Oh, I do dye my hair though. Absolutely. Every 28 days-ish from the grocery store.
And this is a fair and accurate copy of that report.
Yes.
I'm tendering State's Exhibit 4 to defense counsel for inspection.
Still believe it's improper predicate, Judge.
Say it again?
I believe it's still improper predicate.
One more.
Your Honor, going further.
I can't hear you. Just put it on.
Mhm. Well, the only thing I would think is it has been altered in any way, you know?
That's fine. That's fine, Judge. There's still one missing.
Huh?
There's still one missing.
I don't know. I can't think of what you're.
I asked him to say, but if you have an objection.
Okay. I mean, just,
May I tell the court ex parte?
um,
I don't want. I don't know. If I say it.
yeah, I mean, I just,
Did he just say, may I tell the court ex parte?
okay.
Yeah, that's that. I I don't have a problem.
But go, but it's.
Your Honor, going further. Move back.
He's a wizard.
In preparation, I'm letting you forgot what it's on. It's a record of it in context now, which this is some document maintained. I did it. Without me. So the rest of you back here. You still have distinguished. So, I mean, it's their stereo.
I didn't hear you.
That's not.
Okay.
Gentlemen, may I approach?
Please.
All right. I'm showing you again what's been marked as safe and here in full. Are you the custodian of records for these types of things?
Yes,
For this particular one?
yes,
Is this the type of record that's kept in the normal course of business for the Department of Public Safety?
yes,
Has it been altered in any way?
no,
United States is tendering to defense counsel for inspection.
Objection?
No objections, Your Honor.
Record will be admitted.
Judge, you indicated it would be
Yes.
state.
It'll be 4.
Yes, Your Honor.
Okay.
Your Honor, may I publish for the jury?
Please. Still not working. Nothing's working.
And we've already gone over this, but just to refresh, this is the exact document used that is reflective of the results from the specific breath test for this defendant.
yes.
And what were the results of that test?
They were 0.153 and 0.160 grams per 210 meter.
And are these results greater than or less than the legal limit of intoxication set by the state of Texas of 0.08 grams to 210 liters of breath?
They are greater than.
Good, thank you. With the results of these two breath samples within the allowed tolerance specified by the scientific director of the Texas Department of Public Safety.
Yes, they were.
And again, what happens if the two breath samples are not within the allowed tolerance?
So if the two breath samples are not within the allowed tolerance of 0.02, then the instrument will flag an incomplete test with an exception message stating no subject 0.02 agreement.
During the course of your training, did you learn about the effects of alcohol upon a person's mental and physical faculties?
Yes, I did.
Based on your training and experience, how can alcohol affect a person's mental faculties?
So mentally, one of the first things impacted is an individual's judgment. Next, things affected would be an individual's inhibitions. They might start doing things they wouldn't normally do. Their perception, they might start seeing things happening around them that might not necessarily be exactly how they're occurring. Then an individual's vision can be impacted. This can result in blurry or double vision, and especially an individual's tracking ability, so the ability to follow objects from side to side, either while they're driving or walking.
And based on your training experience, have you or yourself conducted or participated in any experiments on the effects of alcohol on a person's mental and physical faculties?
Yes, I have.
And based upon your studies and your own experience, do you have a personal opinion as to the alcohol concentration at which a person does not have the normal use of his or her mental or physical faculties?
Yes, and I would say that would be 0.08, with some individuals displaying signs of intoxication at lower concentrations as well.
Why do you hold that?
I hold that opinion based off of research as well as dosing operators at operator school, as well as myself being dosed at operator school, and just from personal experience as well.
And in your opinion, would a person with an alcohol concentration of 0.153 or 0.160 have lost the normal use of his or her mental or physical faculties?
Hold on.
I'm going to object, Your Honor. I don't believe this witness has been established as an expert, so we cannot provide an opinion.
Really? Response?
Your Honor, based on the witness's educational background that he provided, his training and experience which he provided, the extensive training that he provided, it.
Yeah, I'm gonna overrule the objection. Sorry. Okay.
In your opinion, would a person with an alcohol concentration of 0.153 or 0.160 have lost the normal use of his or her mental or physical faculties?
Yes.
And why do you hold that opinion?
I hold that opinion based off of my training, personal experience, and as well as research as well.
And there's two subject results. Why are there two numbers?
That is because each individual that has the test administered on them, they provide 2 breath samples. Usually in terms of calculations, we typically will go with the lowest of the 2 to give the benefit of the doubt to the subject.
Are the subject's test results a representation of his or her alcohol concentration at the time of the test or at the time of driving?
At the time of the test.
Is it possible to determine a person's alcohol concentration at the time of driving?
Yes, it could be, as long as specific facts are provided, and that would be referred to as a retrograde extrapolation.
Can you explain that process for the jury?
Sure. So it entails with specific facts such as the time of last drink, time of last meal, time of stop, as well as a concentration that an individual blew at a time of test. It is possible to determine what an individual's alcohol concentration would have been at a previous point in time, such as the time of stop or time of incident or time of driving, all kind of referring to the same thing here.
And what is absorption?
Absorption is the process of ingesting alcohol, usually through the form of drinking it, and then it being absorbed into the body largely through the small intestine.
And what is elimination?
Elimination is the body's process of eliminating alcohol from the body. Alcohol is metabolized and broken down by the liver, but it is also eliminated through breath, sweat, and urine, with the breath elimination being the basis for which a breath sample is provided and analyzed through the alkoxylizer.
Given the facts in this case, were you able to extrapolate?
I would need to know those facts before being able to.
State passes the witness, Your Honor.
Okay. Mary Ann?
Yeah.
All right, Mr. Cooper, is it Dr. Cooper?
Just Mr. Cooper.
Okay. I don't want to be disrespectful or anything.
Oh, no, you're fine.
Okay, so your state just finished up their questioning with extrapolation, is that correct?
Yes.
Okay, so you would need a specific set of facts to make that determination, correct?
Sure.
And if you don't have the specific set of facts, you cannot extrapolate back, is that correct?
That is correct.
So again, 0.153, 0.160, that's at the time he blew, but not necessarily at the time he was driving, correct?
Correct.
Now, you talked about the 15-minute waiting period. What was the, or what's the importance of that 15-minute waiting period?
It's to ensure that there's no residual amount of alcohol in an individual's breath that could be leading to a false elevation of the test reading, such as if you were to take a shot of liquor and then immediately blow into the instrument, the excess alcohol in your mouth would read exceedingly higher than what your actual blood concentrations.
Okay, and if the 15-minute period is not observed, would that be a problem?
If it was not properly observed, it would be a breach in our procedures.
And in your training and experience, you indicated that somebody with 0.153 could have lost their judgment and inhibitions, things like that, correct?
Correct.
Also in your training and experience, is it possible for somebody to be below 0.153 and not have lost all of their faculties?
As far as what concentration?
We don't know, but let's say if they're below, because you talk about the body absorbing, right?
Correct.
So your body has to absorb alcohol first, correct? Before it can eliminate.
Yes.
And that's a process that takes some time, correct?
Elimination begins at the same moment that absorption would begin.
Okay. But that doesn't happen like immediately. Like you don't take a shot and it immediately starts absorbing and eliminating, correct?
A small amount is absorbed in the mouth and the stomach lining, with the majority being in the small intestine.
Okay, but in the mouth and stomach lining, that would not register on this machine, correct?
It depends on how much is absorbed. I would assume that it would not lead to a very high reading at all.
So again, if somebody was below this amount, would they lose their mental and physical faculties? Or would it depend on their tolerance?
I would say that all mental faculties are for sure lost at a 0.08. Tolerance that an individual has displayed could affect the outward signs of their physical faculties being impaired.
Okay, so you're saying all mental faculties would be lost?
At a 0.08, yes.
Okay, so a mental faculty would be the ability to drive a vehicle, correct?
Yes, I would say that that is utilized in that.
Okay, so if somebody is still able to drive a vehicle, based on what you just said, that means they would be below a 0.08, correct?
I would say the ability to drive is largely impacted by how well they're driving, impaired versus not impaired.
Okay. So you would expect to see swerving,
Potentially.
you would expect to see maybe an accident,
That could be a possibility, yes.
okay? You would expect to see possibly erratic driving, kind of all over the road, maybe hitting another car or coming close to hitting another car, things like that.
That could be a possibility as well, yes.
Okay. What about speeding?
Yes, I would say that could be an indication as well.
Okay, but have you ever received a speeding ticket?
Yes, I have.
And were you intoxicated when you received that speeding ticket?
No, I was not.
So it's possible to speed even though you have all of your mental faculties, correct?
That is correct.
So speeding is not by itself indicative of intoxicated driving, correct?
Excuse me, but isn't going slow? Like when you're intoxicated, you drive real slow. You don't, I guess some people drive real fast, but most people drive real slow.
No, it could be still a sign of intoxication.
Would you expect to see others?
Potentially.
Sometimes not.
Now, are you familiar with the standard field sobriety tests?
I am roughly familiar with them, yes.
So you're not certified in them, correct?
No, I am not.
Now, this machine you said was last tested on 9/23/24, correct?
Before the subject test, yes.
And you said that the operator at that point forgot to plug in a tank, is that correct?
Nikia Rogers, she forgot to plug in the simulator communication cable, which is what connects the simulator to the toxilizer.
Was that the case when this breath test was taken?
No, that was during her QA inspection.
All right, so just to be clear, these results are at the time of the breath test, correct?
Correct.
And without additional facts, you cannot determine what his alcohol level was at the time of driving, correct?
Correct.
Nothing further, Rich. Okay.
Anything further, state?
Judge Moody, Coach.
Sure.
Used to go.
Scoot on. I know. Well, he testified that there was one that was like, there was different testimony as to the right. So, yeah, I mean, what are you trying to do? How? Not through him.
No, not to him. It would have to be prior. But
You can't use him.
no, I can.
Right. Okay, let's continue. Okay, thank you. So state, do you have anything further?
Yes, Your Honor.
Okay.
Brief.
Make it brief.
Outside the 0.08 number, are there other factors to be considered when determining if an individual is intoxicated?
In regards to mental and physical faculties,
Yes.
some individuals could display signs of intoxication even after their first drink of alcohol. Tolerance also plays a factor as well. But tolerance is only the outward display of being able to mask your physical signs of intoxication, and it has no impact on your mental signs of intoxication.
So it isn't just one specific thing that tells you whether an individual is intoxicated or not.
I'm not really sure what you're asking.
Do you evaluate multiple factors when making your analysis?
I'm gonna object, Judge. I don't know exactly what he's asking. If there's multiple factors as to this breath test,
He's right.
Yes, Your Honor. I'll rephrase.
Okay.
I'll move on.
Okay.
Was everything for this breath test done in accordance with standard policy? Procedures?
As far as what I've observed on the breath records, yes.
Nothing further than stated.
Okay. All right. You may step down.
Thank you.
Yo, that was painful. That was painful to hear. But remember, this is where they sort of start becoming a lawyer. And then they move up to the other courts. This is their training ground. And they don't have a lot of trials here. So he asked exactly what law school told him to ask. Sort of.
State, do you have any further witnesses?
No, Your Honor.
Okay, so you rest.
Yes, Your Honor.
Okay.
I'll have a motion, Judge.
Okay, so hold on. Can you take the jury out for 1 second? But don't take them far. Yeah, but just don't take them far.
All right, for the jury.
Okay, please be seated.
You got right outside the door, there's gonna be a rush.
Sure, of course. For what it's worth, I don't think they can hear anything, but absolutely. Yeah.
Right,
Of course.
sorry.
Absolutely.
So Judge, I'd be asking for a motion to directed verdict. I believe this state has failed to meet its burden beyond a reasonable doubt. First and foremost, they never established whether or not he was operating a motor vehicle. They identified the type of vehicle, but they didn't ask any witnesses if it was a motor vehicle. And that was never established. That's the first part. Second part, I don't believe they've established intoxication beyond a reasonable doubt. They never asked any of their witnesses if the person had lost the mental or physical faculties. All they did was go through the field sobriety tests and indicate what the results of the field sobriety tests were. But none of the witnesses indicated whether or not they had lost their mental or physical faculties. And on top of that, finally, Judge, with this witness, the breath test, he was able to establish that the breath test was done at the time of, or that was his blood alcohol concentration at the time of the test, not at the time of driving. Without any additional information, there's no indication what his blood alcohol was at the time of driving. So therefore, I don't believe they've established the burden as one, as to a motor vehicle. Two, which the complaint or the information says, operated a motor vehicle in a public place in Harris County.
Sir, exactly how the hell are you supposed to give the test at the point of them driving? How? Just do we just make them, everybody have an interlock now?
In Texas. And then also as far as the intoxicated portion, like I said, no testimony as to loss of mental or physical faculties, and no indication that he was at a 0.08 or higher at the time he was driving. So that's why I directed verdict at this time, as the state has failed to meet its burden.
Your Honor, I'll try and go in order here. The facts clearly show that it was a motor vehicle, maybe simply because I didn't ask for a conclusion statement from the witness, but demonstrated that the defendant was in fact driving a motor vehicle by the facts that were given. The officer testified that the defendant was the driver of the vehicle. There was no one else in the vehicle. That he witnessed the vehicle the entire time from when he first witnessed the vehicle.
Yeah, stop. I disagree. I think that there's enough to go forward. You know, I do. I think they testified to it that, you know, we asked them the ultimate question. So, I mean, I think that there's enough to go forward.
But my understanding, Judge, is that the state has to meet each and every one of their elements beyond a reasonable doubt. One of the elements is a motor vehicle, and that was not established beyond a reasonable doubt at all.
He testified that he pulled him over.
Correct, Judge, but it could have been a go-kart, it could have been anything.
He's on video in a car.
Your Honor, the state still has
Okay,
to
no.
establish.
I disagree. I think that they've met it. Let's go from.
We take complete honor.
No, I've got a jury coming in. Give me 5 minutes.
Okay.
Your Honor, I know that you saw the video with a car in it, but no one proved it was a car.
All right, for the jury.
Now, and then we'll do the charges.
Okay.
I'm gonna let them rest and. All right, everybody, please be seated. Okay, so you have rested. Defense, do you have any witnesses?
We do not have any witnesses, Your Honor.
Okay, so defense rests. Okay, so now I'm gonna, we.
But sir, that was your chance. That was your chance to prove that it wasn't a car in that video. Maybe it was something else with no motor. You could have proven that. You could have tried.
Have some business matters to attend to prior to closing. So what I'm gonna do is I'm gonna feed you guys now. I know that you're probably pretty hungry, so I have lunch for you now. We're gonna try to, like I said, be as efficient as possible, so eat. I'm gonna bring you back probably 15 minutes, so we can just get started and keep moving, okay? We're close though, all right? Please.
All right, for the jury.
Oh no. Oh no, what do I do? I don't know what to do. Hold on. Fine. We are at 420. 420. We are at 420. I'm going to fast forward it to get the trial back on track. But if I accidentally pass Victoria, I am coming back. All right.
And the basis for the objection is that I'm gonna say that we, the state and defense, are not in disagreement for the factual basis of the stop. John told me that on direct examination, the officer testified that he ran the defendant's registration and observed that it was expired. Defense did not contest that on cross-examination, so I'd argue that the state and the defense are in agreement as to the basis of the stop.
I did contest it, Judge. I asked him, I said, what you perceived was speeding.
Tested both.
Correct.
Yeah.
You perceived the speeding led you to running his plate, correct? Yes, I said, but if you hadn't perceived him as speeding, you would have not run his
I mean, he
plate, correct?
contested damn near everything. He did.
Okay.
Judge,
I'm gonna overrule your objection. I'm gonna allow it.
I understood the court's made its ruling. I would like to have that language reflected in the jury charge of those two areas for the basis of the traffic stop. The speeding and the expired registration, Your Honor.
Ray?
Judge, I think that the speeding, I think it's fruit of the poisonous tree. When you go into the, are we on the record? When you get into the, speed. When you get into the speeding aspect of it, again, the officer testified that if he hadn't perceived him to be speeding, he would have never run his plate. So therefore, I think that just the speeding alone is sufficient to say he didn't have probable cause to do either one. Either he didn't have probable cause to.
So why do you have a problem if they put both?
Because I believe it would be misleading to the jury, because I'm really contesting the reasoning behind it, the speeding. And then after he perceived the speeding, then is when he ran the plate. It's not that he pulls up next to him that he runs the plate. So I believe, but for the speeding, the plate would have never been run. And even the officer testified to that, because I asked him, you were going the opposite direction, correct? So I think realistically, the biggest contested matter of fact is the speeding, which led to everything.
Okay.
So I believe a 3823 instruction with the speeding is appropriate.
And I do have a response, Judge.
Sure.
So yes, the fence is mentioned as fruit of the poisonous tree. I don't see any indication of how getting behind a vehicle that he thinks is speeding is any sort of search or any sort of privacy interest that exists in that mere fact alone. While he was
Contesting the stop.
He's contesting the stop. Yes, correct, Judge. And if I may, counsel, if there's two bases for the stop, then that should be reflected in the jury charge. It's
What's the 3823 just on the speeding?
just on the speeding.
Oh, am I right?
That's correct.
Okay, so I'm gonna give you just that what you're asking, right?
Judge, I believe the way it's currently reflected in the instruction would be misleading to the jury, because it says, before you may consider the evidence obtained as a result of Officer Metter's stop and detention, you must all agree that the state has proven beyond all reasonable doubt that Officer Metter reasonably believed that the defendant was speeding before Officer Metter stopped him. The state's arguing that it's not that he has to show that he was speeding and that's why he stopped him. The state's arguing that that's misleading because he can get behind him even if he thinks he's speeding. And then if he happens to run the registration before he initiates the traffic stop, which he did in this case, and it was expired, that is sufficient for reasonable suspicion and probable cause to initiate the traffic stop on its face. The way this instruction is currently written, Judge, it's asking like, well, if he wasn't speeding, then you suppress all evidence.
That is correct, Judge.
I mean, I think, I agree with that too, you know,
I
because
can
they
see-
do, if he wants to run the plate just because it just wants to run it, he can do that. There's no law that prevents him from doing that.
Correct, Your Honor, and I can see that argument, which is why I specifically asked him, if you hadn't perceived my client to be speeding, would you have ever run his plate? And he said, well, I can run plates whenever. I said, in this particular instance, would you have ever run his plate? And I believe he said no. So if the court recalls on dash cam.
I understand it, I get it, I get it.
If my client had just,
Still,
Dude, that's irrelevant. 100% irrelevant.
fall through the intersection, he would have, Officer Metter would have continued straight. He was gonna go straight.
how do we appease both of you in this situation?
Judge, let me tell you how this can happen. In the second paragraph on page 5 of the jury charge, it says you may consider this evidence, referring to the evidence that comes from.
Wait, where are you?
I'm on page 5 of the jury charge.
There's no.
Oh, sorry. It is under disregard evidence if unlawfully obtained. The second paragraph is just one sentence, Your Honor. You may consider this evidence only if you resolve a preliminary question in favor of the state. It then goes on to say that you need to address the issue of if they're speeding. That is going to inform the jury that they need to only consider the speeding and just disregard the other lawful basis of the stop.
You talking about the third paragraph?
The second.
No, it's where it says, before you consider evidence obtained as a result of Officer Mike Commander's stop, you must all agree that the state has proven beyond a reasonable doubt the officer reasonably believed that O'Dear was speeding before Mike Commander stopped him, right? So, but there are other ways, right? Because he used in his testimony 2 ways. He also said that I did both. It's fair.
I can see that argument, Judge, but my position is still the same.
I get it.
Yeah.
So how do we put that in the language?
Judge, the easiest way to do that would be to say that, I'm looking at the bottom paragraph of that page, Your Honor. You must all agree that the state has proven beyond a reasonable doubt that Officer Mike Metter reasonably believed that the defendant was speeding or had expired registration.
Right?
I would still object for the same reason, Judge. I believe that the order expired registration is.
Okay.
For the
I guess I'm
case.
going to overrule your objection because we'll just put or registration, I mean, unless you have a better wording for it. And or. Are you happy with that?
I was going to say the same thing. You beat me to it.
Yeah, because it's and or. It could be or. It could be both. Yes. Are you happy with that?
That's fine.
Okay, done. So just put and or, and then after that, no objections from the state?
I saw, no, never mind.
Just a moment, Judge. I haven't read the last page here of the jury charge. Separated and, yeah.
He has. Yeah. I think it's 1, 2 should be physical, 3 should be. That's how I perceive.
I do think that, it's been a minute since I've seen
I haven't.
I do think it would make it more clear if the jury do have one mental faculties, 2, or physical faculties, 3 to point of birth.
Yeah. Right, like 1, 2.
Yeah. Oh, you decided to do it that way anyway? Yeah, to back up. Okay, not a problem.
Yeah, I don't have to go to JPC.
Yeah, no, absolutely. All right, I'm signing it for you.
I mean, I don't know. It's, that doesn't bother me one way or the other.
Okay. Is there another issue?
I don't think it's a huge problem, but if the state wants to address it, I have no problem fixing it.
I agree with defense judge. I don't see it's much of an issue. It's just that on the page.
On the definition of intoxication, Judge.
What about it?
I think, I would like to.
Okay.
Yeah.
Yeah. We would just like to clarify that to number it as 1, 2, and 3, 1 being not having the normal use of mental faculties, 2 being not having the normal
Yeah,
use of
no, that's
physical.
right. It's gotta be 1, 2, and 3. Right. Yeah. That's okay.
All right.
Yeah, I have no issues with that, Judge. Okay, so we'll fix those and then no objection, we get them in here. We just, you know, all right.
No objections, Judge.
That's the way you have it.
So it should be one and that would be
How much the restoration? What do we
two is or
Okay, is it in mine or is it in there?
It should
Okay,
be.
I'll sign
But I think it's at the top of your queue right there.
Got it.
Oh, okay, okay, I see what you're saying.
So these just
Give
may
them
be
paragraphs,
here.
it's gonna have it on one big paragraph.
Correct.
Okay.
All right, cool. Thanks.
Anthony, knock it off right now. Knock it off. Okay, guys. I have a feeling. Oh no, my cat just stepped all over the keyboard. All right. I have to say something. I know we don't talk politics. I know we don't. I'm about to say something, and I 100% realize that this might be the last time I see 50% of you. I'm okay with that. I have to. I can't go to sleep at night. Money is not worth my voice. I have to say something. Mods, just let them comment how they comment. You don't have to do anything about their comments after what I say. You can go drink some coffee or something, maybe some alcohol. There's so many hills, that you can die on right now. There's so many hills that you can say, this is not right. This is absolutely just not okay. And I know the other day I did speak about the people that are just being taken away. No evidence, no trial, never see their family again. Never. They're just being taken away. And everybody, you guys did really good with that. I have one more thing to say. I can't help it. I have to. Children with autism, they will never pay taxes. They'll never hold a job. They'll never play baseball. They'll never write a poem. They'll never go out on a date. Many of them will never use a toilet unassisted. Autism destroys families. And more importantly, it destroys our greatest resource, which is our children. That is what the head of the Health and Human Services, the secretary, said with his full chest. Yeah, Monica, yeah, well, she's the problem. That's what he said with his full chest. That is what they are. That is what. How dare he? How dare he say those words? I sat on those words for days. There's so many things I don't say in this channel because I can't. But that is bullshit. That is ridiculous. That is unacceptable. That so the government now, I'm just letting you know, is taking most of the Americans' personal medical records. to fund people with autism. Because people with autism are destroying American families. Is that what the media is telling me, Anthony? That's not what he said. Anthony, are you saying he didn't say those words? That the media is telling me he said those words? Because I fucking heard him say those words. I watched him say those words. So you're saying, oh, do more research? No, no, I'm not going to do more research. I'm not. If you are okay with him saying that, you know what? You keep supporting that. You just go right ahead. Guys, it's not okay. What that is not okay. Fuck politics and this and that and this and that. That is not okay. People being just taken away and never seen again is not okay. All right. This isn't just about politics. This isn't just about, oh my God, if this person's in, we're going to have to pay more for gas. Who the fuck cares about gas? I had to say that because I couldn't sleep at night not saying it. I don't care if I lose my subscribers. My voice is more important than money. All right. I'm going to go back to the trial now. Thank you. Closing statements.
All right, please be seated. Okay, filet and lobster good? Okay, members of the jury.
Scientifically, that's just not possible. Toxins. Come on.
The defendant, Odir Alberto Gamez Santamaria, stands charged by information with the offense of driving while intoxicated in Harris County on or about October 6, 2024. To this charge, the defendant has pleaded not guilty. Both sides will soon present final arguments. Before they...
Victoria, I need you. I messed up. They're about to do closing arguments. I don't know if you know the answer to this or not, but when did the judge call you? Was it before closing arguments? Because if it was around 4:20. So, or was it after, or was it during? When did the judge call you? Do you remember? Probably don't even remember.
I now give you the instructions you must follow in deciding whether the defendant has been proven guilty or not. You will receive a written copy of these instructions to take with you and to use during your deliberations. Both sides will soon present final arguments. Before they do, I now give you the instructions you must follow in deciding whether the defendant has been proven guilty or not. You will receive a written copy of these instructions to take and use during your deliberations. First, I will give you some general principles of law that you must follow when deciding this case. Then I will instruct you on rules that control your deliberations. Finally, I will tell you about the specific law that applies to this case. The information. The information is not evidence of guilt. It is the name of a document required to bring the case before you.
Okay, I'm not listening to the jury instructions. I'm not. I think Bill had it. You can watch Bill's. Go watch Bill anyway. Is that a PAPA? Is that Papa? Smurf. No, it's not. It's this way. That's Dad. Oh, I missed some. Guys, I can't miss some of the closing statement that we're not going to be able to hear.
I told you at the beginning of this case in my opening of the things you would not hear. I told you would not hear what his exact speed was. And I told you would not hear what his blood alcohol content was at the time he was driving. Out of all 4 witnesses that the state has put on, not a single one of them could say that with absolute certainty. Nobody can tell you either one of those facts. You heard from the analyst who said that he would need specific facts to determine what his alcohol level was at the time. We talked about absorption, how alcohol enters the body, how it takes some time for the alcohol to enter the body. And when asked, can you do that in this case? I believe the state asked him that. He couldn't. So we don't know what his blood alcohol content was at the time of driving. We know what they claim it was, or what the sheet shows it was at the time that he blew. That doesn't mean that's what it was when he was driving, right? Then he talked about the mental faculties and physical faculties. And the analyst told you that he believes somebody with a 0.08 loses all faculties, right? And I asked him, does that include driving? He said, yes, I believe it includes driving. I said, would you expect to see other driving patterns? Would you expect to see swerving? Yes. Would you expect to see an accident? Yes. None of that happened here. It was supposedly speeding was the only issue, right? Now let's talk about the speeding. Officer Metter driving northbound on South Chestnut. He says he knows that intersection well because the station is not far from there. And he knows how fast somebody's going because of the flow of traffic that goes here. There was not a single car on that road, not one. He admitted it. My client had the green light. He didn't run a red light. In fact, we see him stop at the appropriate place at the next intersection. So it doesn't run a red light. There's no traffic to compare his speed to. Metter waits 10 seconds before even pulling out, or 8 seconds before even pulling out and go after him. And then when he does go after him, he claims he hit 64. He says that you can see that on the video. We didn't see that on the video. There's nowhere on that video that doesn't show what his speed was. Why? Because we don't know what his speed was. That's just what he said it was. Right? The evidence speaks for itself, ladies and gentlemen. Evidence speaks for itself. So then he says it's about a quarter mile to the next stop. So if he's doing 65, and my client's doing 65, he even admitted to you, Metter admitted to you, that my client would have been long through that next light before Officer Metter even hit it at a quarter mile. He was not doing 65, ladies and gentlemen. In fact, we don't know how fast he was going. Why don't we know how fast he was going? Because Metter didn't try to put a radar on him. He didn't try to do anything except pull out and say, I'm going to go stop this guy. And then when he gets up there, here's where the state wants you to say, oh, this is the problem. This is a reasonable cause or a probable cause for the stop and stop. He runs his plate and finds out the registration was expired. Okay. I asked Metter specifically, is expired registration indicative of intoxicated driving? Of course not, right? It's a fix-it ticket. That's what you get. You gotta get registration, pay the ticket, case gets dismissed. So, and I asked him, but for the fact that you perceive my client to be speeding, would you ever run his plate? He said no. Why? Because he was going the opposite direction. He was going northbound, the client was going eastbound. Westbound. Had to do the never eat soggy Wheaties. Yeah. So client was going westbound. Complete opposite direction. So, but for Metter thinking that he was speeding, he would never pull up behind him. He never pulled up behind him. He would never run his plates. He never run his plates. He would never have seen the registration was expired. And therefore, my client would never have been pulled over. let's talk about the investigation itself. When he pulls into the gas station, Metter realizes Mr. Gomez doesn't speak English very well, so he calls for a Spanish-speaking officer. Ruiz shows up. Ruiz starts talking to him. And Ruiz told you that he didn't translate everything verbatim. He paraphrased it, is how he put it. Metter testified that there were inconsistencies in my client's statement, which led him to believe that he maybe didn't have the mental use of his faculties due to intoxication, right? But there were no inconsistencies. Well, you heard Ruiz talk about coming out from Cleveland, helping the client move. Ruiz didn't translate that all. All he said was he came from Cleveland and he helped a friend, right? Then later on, he says again, he helped a friend move. And then Ruiz says that. And then Metter tells you, well, that's an inconsistent statement. He told you he came down to get gas. He was coming from his house to go get gas because gas is cheaper on the side of town, right? That's what that's what the client said, right? And Ruiz said that. Officer Metter says, oh no, that's an inconsistent statement. He never said anything about getting gas before. He said he had come down, helped a friend move. He said that the first time, and he said it the second time. And then they asked him, well, where is he going? He said, I'm coming down here to get gas because it's cheaper, right? So he came to get gas because it's cheaper in that thing. Then Metter goes on to talk about, oh, I pass all these gas stations. Well, we all know there's gas stations everywhere. Every single gas station has a different price. I know I've got my favorite one I always go to, and I will pass a dozen other stations to get to that one to get the cheapest price on gas, especially nowadays, and especially coming into the summer months. We all know that. So everything that Metter told you or used in the totality of circumstances is perfectly reasonable. Now let's talk about the field sobriety tests. They want you to start right here, like this. Right? I'm struggling to do that. And I have perfectly good balance. You start here, and then you've got to do heel to toe for 9 steps, and then a series of small turns. I know the SFSTs inside and out. I was a prosecutor, I was a police officer, a prosecutor, and now a defense attorney. I've done these thousands of times. I've seen them thousands of times. All right, so I can do them. My client got one time on the instructions. Metter claims he took 8 steps instead of 9. Okay, maybe he miscounted. All right, and then a series of small turns. They expect somebody to do this to turn around. All right, that's not a natural movement. Everybody, when you turn around, when you're just thinking, I got to turn around and go back, you get to the end, you turn around, and you go back. No falling over, no stumbling, nothing. Just an unreasonable test that is perfectly unnatural for a human body to perform. And he claims that the National Highway Safety and Transportation Committee established these so that it would be difficult. Sure, maybe that's the case. But even a sober person, I believe he even said, somebody, what were his exact words? It was relatively easy for somebody who is not intoxicated. Not completely easy, not perfectly easy, not easy at all. Right? Relatively easy for somebody who's not intoxicated. So the field sobriety test, useless. Absolutely useless. And then he talked about, him and Ruiz both said, there's a strong odor of alcohol on his breath. Right? But then I asked, if you have 1, maybe 2 beers and have a strong odor of alcohol on your breath. Yes. I asked Metter, if you have 2 beers, are you intoxicated? No. And then we get to Varner, and Varner says it was a moderate to mild odor of alcohol on his breath. Which one's the truth? We don't know. We weren't there. But that's completely unreliable as well, because there's inconsistent statements. If Federer wants to use the inconsistent statements, that's an inconsistent statement amongst the state. These are the people that work for the prosecutors. This is their job. Their job is to find people guilty, for the state, not prosecution. Their job is to look for things to find people guilty. Right? That's what they try to do. So they're going to say what they want to say to get to that point. Now, as far as the jury instruction, there's a section in the jury instructions that says you are to disregard evidence if unlawfully obtained. Page, I believe it's 5. 1, 2, 3, 4, 5. Page 5. An entire section talks about evidence unlawfully obtained. I've already explained this to you, but I'm going to go over it again. Matter says he knows that intersection. Based on the flow of traffic, he believed my client was speeding. There wasn't traffic. He couldn't go after him. He couldn't tell how fast he was going. And he goes out after him. A quarter mile later, he catches up to him and runs his plate. That is, without him thinking that my client was speeding, he would never run that plate. That's unlawfully obtained evidence. He just looked for something to find.
Objection, Your Honor, let me approach.
Oh, bad show. Bad show.
Well, just, I said, but for him going after me. Or so. Okay, that's an ambulance. Right, and so. So you can as well. All right, come on. In 3 minutes.
So, again, speeding goes in behind one's plate. That tells you here down at the bottom, and or expired registration, right? What I'm asking you to think of is, why did he find out that registration is expired? What led him to that? But for him perceiving a speeding, he would have never run that plate. And if you find that probable cause did not exist, or as well as you don't believe that he lost his mental faculties, we didn't see him fumbling, we didn't see him walk, urinating himself, we didn't see him everything during jury selection. I think somebody said that. You know, they urinate themselves, right? They stumble, they act a fool, they're belligerent, things like that. We didn't see any of that. What we saw were those unnatural field sobriety tests that are designed for people to fail. That's what we saw. Nothing else. No other driving facts. So no loss of mental faculties, no loss of physical faculty.
They can absolutely run any plate whenever they want to. They don't need a reason.
And then they say at the time that he blew, his alcohol was 0.153, but nobody can tell you what it was at the time he was driving. The law is driving while intoxicated, not intoxicated when you blow into the machine. Driving while intoxicated, which means they have to prove beyond a reasonable doubt that at the time he was driving, he either lost his mental faculties, lost his physical faculties, or was at 0.08 or higher. They have proven absolutely none of that. So, ladies and gentlemen of the jury, you have one verdict and one verdict only. It's at the very top right there for you. We, the jury, find the defendant, Pudero Alberto Gomez Santa Maria, not guilty. Thank you very much for your time.
Okay, thank you. All right, state.
Thank you, Judge. Judge, may I publish a PowerPoint for the jury? May I publish a PowerPoint for the jury?
Sure.
All right, I'm expecting this one to be kind of good. He did good in this trial so
All
far.
right. Defense said a lot of things. Some of it confusing. Some of it, right? Let's start with the jury questions. This piece he pointed out to you said disregard evidence if unlawfully obtained. There's a piece I want to circle here. It does not say if you that you must all agree the state has proven beyond reasonable doubt that Officer Michael Metter reasonably believed that the defendant was speeding. It says was speeding and or had expired registration. There's no reason hard. The officer thought he was speeding. He goes to the line, the officer sees him, he follows him, he tracks him, he pays him. Was it perfect? No. But he gets up to the light and he runs his registration. He finds that his registration is expired. That's all he needed. That's it, right there. That's what the jury instruction says. It says or. If you find that he had expired registration, it doesn't matter. Look at all the evidence. Now, let's go through this and let's make it easy. Like I told everybody. Every single person, except for the last witness, said that this occurred on October 6, 2024. That's an easy one. Let's cross that one off. The officers both said it was in Harris County, Texas, and in a public place. We know that it was this defendant. How do we know that? Because the officer said it was. Because the officer said, I was going down the road, I saw this car, I pulled him over, and he was the one behind the wheel, and you see him on the video. Let's cross off another one. Operated a motor vehicle. How do we know that? You saw it on the video. The officer told you everything you need to know. It's not hard. In a public place. You see on the video, he's at a gas station. The officer tells you he's at a gas station. And he's operating a vehicle on a public roadway. Straight from the officer. It's not hard. None of those are hard. And fairly useful. Then we get to while intoxicated. This is still easy. Why is it easy? How do we know he was intoxicated? Because I have this piece of paper that says subject name that has the operator that you heard from his signature on it. And it says what his DNC was when he blew. Now, this is important. What does it say? Let's use the low one, 0.153. This is a smaller detail that you may not have caught, but you have to use your memory. Think back. When the officer was telling you about the HGN, you remember there was a small part at the end of the HGN where he said onset, he was talking about the onset prior to 45. And it's what the officers used to calculate about where the defendant is on the scale. He told you what he thought the defendant was at that point in time was what? It was around 0.15. And then when you got a breath test and confirm it. So it is. It doesn't have to be hard minutes. Remember yesterday we were talking during jury selection, and I brought up Stonehenge, and I said, and I told you, you might not have the full picture. But you don't need the full picture. When you get enough pieces together in a puzzle, you know what the picture is. And that's all this is here. We have all the pieces we need. Only thing left for you to do. So go back in the jury room, pick a format, and return a guilty verdict. That's what I'm asking you to do right now.
All right, thank you. All right, ladies and gentlemen of the jury, it's now time for you to deliberate. If you want, do you mind escorting them to the jury room?
I'm not fast forwarding it because any second now, I feel like I'm gonna hear Victoria. I just feel it.
Okay, all right, so. Good luck. Judge.
The best part of the trial is happening.
Okay, we're in recess. I just want to remind him not to put the alternate in the room with them. That's what I was saying.
What was it?
Not to put the alternate,
Oh, okay.
because ours.
They need to go take that sticker.
Oh, right.
2, 3, 4.
Hey, come on. Oh, wait.
We have states 1 through 4 and defense 1, right?
Victoria doesn't hide. She makes people hide. Clea, yes. Trial in Judge Fleischer's courtroom. The jury is out deliberating. This isn't the right part because she's here in person. It was when she was on the phone. Oh, there's Ramona.
Oh, that's what. It's because Judge Simon beats the bail order.
Right, I'm fast forwarding to the part because
We already told her she
Clea
was back
made
from
the part.
the.
So.
Take him away, guys. They're taking the judge to jail. Sorry.
See what they.
Oh, wait.
Have you reached a verdict?
I
Is it unanimous?
I don't know where it is.
Okay. I'm now going to read to you in the state of Texas, cause number 2532700, the state of Texas versus Odir Alberto Gomez Santa Maria. We the jury find the defendant guilty of Class A driving while intoxicated as charged in the information. Okay, you've been found guilty. You may take a seat for a moment. Does anybody who would like the jury polled?
Yes, Your Honor.
Okay. Ladies and gentlemen of the jury, is this your verdict, man? Is this your verdict?
Yeah.
Is this your verdict? Is this your verdict? Your verdict?
Yes.
Your verdict. Okay.
Thank you.
All right, sir. Just give me a second. Ladies and gentlemen of the jury, you have concluded your service. I thank you for everything that you have done. It's really an invaluable service. You may now retire to the jury room. If you give me a couple minutes, I'll come back there and talk to you, and then we'll try to get you all the things that you may need to get you out of here. Yeah. Thank you.
All right, for the jury.
You're not my father.
Please be seated. Mr. Gomez, I want you to understand that you do have the right to appeal this verdict. If you decide to do that, there are certain timing requirements that must be fulfilled and documents filed. I can let your attorney explain as much as he knows, if that's something that you want to do, but timing is of the essence if you want to appeal this, but you do have that right. We do have to sentence, and if I'm correct, parties, you have agreed to a sentence.
Yes, Your Honor.
Okay, and the agreement is
210 days.
with credit for the 73 days. Okay. I'm now going to sentence you to 200 days in jail. I will give you credit for 73 days that you have done. Mr. Gomez, you need to understand that this will now reflect as a conviction on your record. This now makes 2. If you ever pick up another DWI, you will be charged with a felony offense, and you will be looking at a minimum of 2 years in prison, a maximum of 10 years in prison. I would never, even if you've had a sip of alcohol, get into a car and drive because you are taking a huge risk. Do you understand? Okay, so you may be seated, and I think that.
Are we gonna keep it as a second with the Class A?
Yeah.
1.5?
Yeah.
So you're making sure, okay.
Yes. Well, they found it.
No, they found the 0.15 shoe. The second is an punishment enhancement, which would need to be found shoe as well.
Guilty.
Yes, we'll stipulate to the first.
Okay.
Doesn't change anything.
Right, okay, so we need him to sign documents, so just don't send them down until the documents are ready to be signed. I'm gonna suspend the license for a year, okay? Do not drive until you get a license. Otherwise, you'll be right back in custody.
Just for the record, Judge, although I've admonished him, the court admonished him that this could have negative effects on his immigration status.
Right, okay, yes, that's in fact true, right. You being found guilty of this DWI offense, this can and probably will impact any kind of immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You have an ICE hold now, so you know now that there are immigration consequences for future purposes. When you're on bond, don't violate, there are severe consequences, as you now know. Anything else you'd like? State?
Or
No fines. Yeah, no fines, nothing else, just, I'll waive any kind of surcharges that will be imposed by the Department of Public Safety. Right, so if you don't mind, give me the motion and then I'll sign it for you.
Thank you, Your Honor.
Okay, all right, so just hang tight, but don't send them down just yet. Okay, all right, let me go talk to them real quick and then I'll let you guys go talk to them as well. We are done.
Well, I don't know where Victoria was. We missed it. It was in there somewhere. 5 hours and 15 minutes. It's somewhere in there. I just don't know where. So we didn't get to hear it. I heard it though. It was fabulous. All right, guys. Thank you so much for coming out today. I really, really, really appreciate it. You're going to get bumped over to OJ. And like, we don't have enough corruption and criminals dealing with now. We're going to watch OJ for more corruption and criminals, blatant criminals. Johnny Cochran, when the witness is on the stand and they ask the witness a question, Johnny Cochran is like giving them signals of how to freaking answer the question. Yep, yes, he is. Criminals. I'm not going into it with my blood pressure raised, though. I'm not. I'm gonna. It was. I don't know. Was there an outcome? No. He was guilty. He got like 200 some days in jail, suspended license for a year, 70 some days of credit. Not my new hair color. It's like you don't even know me. It's like you've been watching someone else for the last year or two. Bye, guys. Thank you so much. See ya.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. Wicked stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's life.